It's been a tense political day, and joining us now is advocate Ran Bar Yoshafat from the Kohelet Forum. Ran, is it even legitimate that the High Court consider a basic law, and even more so, a basic law relating to its own powers?
Well, in my opinion, the answer is a big no. In the Mizrahi verdict in the mid-90s, the Supreme Court of Israel had a theoretical question, which he should not even address, in my opinion, because that's not the place of courts to decide if Israel has or doesn't have a constitution. And basically, the court said that basic laws are somewhat of a constitution, even though the main difference between a basic law and a regular law is just that it says basic law in the beginning of the name of the law, the headline. So the Supreme Court basically said that basic laws have a higher normative level. If that's the case, nothing can be above these basic laws, because that's like a Supreme Court justice in America saying the Constitution is unconstitutional. The mere fact that the Supreme Court in Israel is currently discussing if a basic law is okay or not okay is extremely problematic for democracy, because if they decide that a basic law is not okay according to their personal belief system, what is above that? What is the source of authority that gives the Supreme Court the power to act?
And the Kohelet Forum you're affiliated with helped formulate much of the government judicial reform. Is this what you had in mind? I mean, what's happening now?
To be fair here, Minister Yariv Levin and MK Simcha Rothman have been working on the legal reform for the past 20 years. That's long before Kohelet was created. What Kohelet does, we are a think tank. We do comparative constitutional law, and we expose the fact that sometimes we have anomalies in the law. For instance, there are certain ways that only in Israel judges are being appointed. The way it is then being constructed and conducted in a bill proposition, we have nothing to do with these things, because that is for the decision of the policymakers, the politicians themselves. Just to show what is happening, that is called comparative constitutional law, which is, by the way, not different than any other think tank that we have in Israel from different political views. We're very proud in the fact that we were able to expose the fact that we have some problems in the judicial system in Israel, mainly in the sense that when you're checking our checks and balances, you see that the final word is not for the public or not for their elected representatives. And we understand democracy in the fact that the people have to have the final word, and not judges who are not elected by the people.
First of all, you're saying 20 years. That's an interesting number. What's been done all these years?
Well, if you look at the Knesset's website, you can see so many proposals, even in the previous government. You know, you don't have to go 20 years ago, but you go to last year's government, you had very similar propositions. In fact, MK Simcha Rothman said several times in his committee, he asked MK Michal Shir, he said, "You're not happy with the proposal? It is the exact same proposal that Gideon Sa'ar gave in the previous government." He told MK Matan Kana, "Matan, you're not happy with my proposal? I'm going to take it down and use your proposal from 7 months ago. Would you be okay with that?" When the New Right Party came to be, their platform was the legal reform, or maybe a little bit more to the extreme. From Yaakov Ne'eman as Minister of Justice, from Daniel Friedman under the Olmert administration, even Ehud Barak when he was a member of the Netanyahu cabinet in the first early 2000s, everyone was trying to support such a legal reform. The fact that it's now so controversial, I think it's a lack of a better way of the government to explain what they're actually doing. But to say that this is a new concept or something that people have not been working on for many years is very, very strange. From Tzipi Livni to, again, Daniel Friedman, Matan Kahana, Gideon Sa'ar, Ayelet Shaked, obviously, all these politicians were trying to make sure that when we're talking about checks and balances, the final word belongs to the people and not the unelected judges.
How long do you expect it will take for the court to really make a ruling? And if they throw out the law, are we into a real constitutional crisis?
First of all, we are already in a constitutional crisis. And I think that the main problem is that people forget that democracy is the rule of the people. Now, I personally believe in a liberal democracy, which means that you always have to have restraints on the current legislator, that they will not change the rules of the game in such a way that it will no longer be a democracy. And you also have to make sure that you always have the protection for the individuals. That's, for me, it's a given. But what is happening right now is a question of who decides when we cannot reach an agreement. Is it the people, or is it a Supreme Court judge? By the way, it doesn't have to be the Supreme Court. The situation in Israel today, for instance, is that a regular court can cancel a law. The fact that we're having all this dispute regarding the reasonable clause is quite staggering, in my opinion, because when I was going on different panels trying to find agreements with people who disagree with me, that was never the case. Everyone was always concerned about the override clause, which I also disagree with, the override clause in the original proposal by Minister Levin. But no one ever said that there's a problem with the reasonable clause, because we basically are asking, we the people, asking for the judges to rule according to the law. So we are already in the midst of a constitutional crisis.
Ron, too fast. Definitely not the case here. Thank you so much for joining us today.
Thank you.